the case against President-elect Uhuru Kenyatta by amending charges. One of the witnesses in the two Kenyan cases had scheduled a media briefing today to lay bare the motivation behind being enlisted as a prosecution witness, but the briefing was later cancelled. Is the ICC facing hostile witnesses, or some of the witnesses purged themselves? And do they risk facing perjury sanctions for lying to the court? Sam Ogina reports.
Good afternoon, everyone. Please be seated.
The bolting out of a second prosecution witness in the two Kenyan cases at the ICC has caused a stir among many observers. The withdrawal of witness 4 in case number 2 against President-elect Uhuru Kenyatta and former head of Civil Service Ambassador Francis Muthaura effected the collapse of Muthaura's case,
providing for sanctions.
But it is the subsequent withdrawal of witness number 8 in case 1 against Deputy President-elect William Ruto that has raised speculations among pundits.
Further consequences of such kind of withdrawal is also to taint the credibility of the entire process.
But of immediate concern is the conduct of prosecution witnesses recanting evidence they gave under oath. The two witnesses setting a worrying trend, of which experts say they are guilty of perjury, otherwise lying to the court under oath, and the ICC prosecution can decide to take up punitive actions against lying witnesses.
Lying under oath is obviously an offense.
In such a situation, the court may sanction the person who has lied or bribed the witness, imposing a fine and/or a term of imprisonment not exceeding 5 years.
Equally, the prosecution can press sanctions against the accused if found inducing or intimidating witnesses. But despite claiming that witness 4 was bribed into recanting his statement, the ICC prosecutor has not pressed any sanctions against any of the accused.
That kind of interference amounts to offenses under the Act or under the Rome Statute. That is interference with the lawful administration of justice. So it is upon her to then invoke the right machinery of trying to get evidence to actually prove those allegations as against the witnesses, and then legal action can be taken against them.
Experts are now pointing glaring inconsistencies in the ICC cases, given the pattern of the cases crumbling. From the Ocampo 6 to Bensouda 3, at the confirmation of charges hearings, former Police Commissioner General Hussein Ali and former Tinderet MP Henry Kosgei cases were not confirmed owing to insufficient evidence. The collapse of Muthaura's case is equally attributed to lack of sufficient evidence. And now, Bensouda's predecessor Luis Moreno Ocampo is accused of conducting shoddy investigations, now weakening before Bensouda.
It's a very serious indictment on the part of the office of the prosecutor. It raises very many questions as to how the investigations were conducted and how this trial was commenced in the first instance, and how prepared the prosecution was with regard to these particular cases.
So thank you very much. The hearing is adjourned.
Sam Ogina, KTN.